On June 4, 2026, I read a letter from the director of the Ashford Community Pantry. One sentence said, "She still arrives 20 minutes early, and the boy who made everyone laugh in your courtroom now carries the folding tables beside her." I read that sentence twice. I want to tell you how we got there. The law gave me a range in this case. People outside court do not always see that part. They hear the sentence and think it fell from the ceiling. It did not. I chose the lower end of what the law allowed, and I chose it because the facts led me there, even though from the outside it would not have looked obvious. I want you to subscribe before I keep going. Not because what I am about to tell you is dramatic, because it is the opposite of dramatic, and those are the stories that need the most people to hear them. Subscribe and turn on notifications. Then let me continue. The file reached my desk in late December of 2025. It was a misdemeanor theft by employee case, already set for sentencing after a guilty plea. The loss amount was $2,140. The business was Whitaker Floral and Gifts at 611 North Main Street in Ashford. The possible sentence was up to 365 days in jail, a fine of up to $5,000, restitution, probation, or some combination of those. On paper, it looked plain. Employee steals from a small business. Owner discovers it. Police interview. Admission. Guilty plea. Sentencing. A short line from charge to consequence. But I have spent enough years on a bench to know that some of the straightest files become more human the moment the room fills up. I ordered a presentence investigation before the hearing. In simple terms, that meant I asked for more than the charge sheet. I wanted the work history, the family picture, the payment attempts, the risks, the record, the things a person was carrying before and after the offense. That is part of my discretion. It allows me to slow down before I decide what accountability should look like. When Marisol Vega walked into my courtroom on January 22, 2026, at 8:58 in the morning, she was holding a flat manila folder against her ribs with both hands. She wore a navy cardigan with one loose button near the middle, and she kept one finger resting over that button, as if she did not trust the sweater to stay closed without help. Before she sat down, she turned and checked whether her son had taken off his backpack. That was the first thing she did. She was 38. No prior criminal record. What I saw from the bench was a woman trying very hard not to take up any more trouble than she already believed she had caused. That does not erase theft. It does tell me something about the person who committed it. She nodded before her lawyer finished speaking, the way people do when they are trying to make themselves easy in a place where they feel they have lost the right to be difficult. Linda Whitaker entered 3 minutes later through the witness door. She was 57, the owner of the flower shop, and she carried reading glasses in one hand and a hardback ledger in the other. She did not rush. She did not perform anger. She sat nearest the aisle, not the seat farthest from the defense table. From the bench, that told me she had not come to hide from the room. She had come to say exactly what needed saying. What I noticed about Linda Whitaker was her discipline. She did not look at Marisol right away. She looked at me, then at the clerk, then at the witness chair, as if she had decided in advance that she would not let anger do the speaking for her. When she finally looked across the room, it was direct and steady. There is a kind of clarity people bring into court when they know what they need and what they do not. She had that clarity. The theft itself took place between Tuesday, October 7, 2025, and Tuesday, November 18, 2025, usually between 4:10 p.m. and 5 p.m. near closing time. Marisol was responsible for counting cash drawers, writing the daily totals, and preparing deposit slips. Over 7 weeks, she altered cash sheets, lowered listed totals, and removed money before deposit bags were sealed. The first proven shortage was $60. The largest single shortage was $480. The total was $2,840. Linda Whitaker found the pattern after a Friday deposit failed to match the register summary. She spent 2 nights going back through receipts, camera timestamps, handwritten totals, and deposit slips. By the time the police were called, she had already done careful work. I do not say that lightly. Harm lands differently in a small business. Missing money is not an abstract loss. It moves through payroll, supply orders, and sleep. When detectives interviewed Marisol on November 21st, She did not deny what she had done. In the summary I received, she said, "I took the first $60 because my gas shut-off notice said 11:59 p.m. and I thought I could put it back by Friday." Later in the same interview, she said, "I called it borrowing so I could sleep, but it was stealing every time." Those two sentences mattered to me. One explained the fear, the other named the crime without hiding. Subscribe before I keep going. I made a choice in this case that I want to explain fully. Subscribe now, because the reason I made it is coming, and I want you to be here for the whole explanation. The prosecutor asked me for 180 days in jail, with 90 days executed and 90 suspended, plus full restitution. The defense asked for probation, counseling, community service, and restitution. That part was ordinary. What changed the shape of the case was what came in through the presentence report and then what happened in the room itself. The presentence report showed Marisol had already made 3 small payments before sentencing: $100 on November 24th, $75 on December 3rd, and $125 on December 17th. Small payments do not erase a theft. They also are not meaningless. They told me she had not waited for a court order to begin trying to straighten something she had bent. There was another legal tool I was glad to have. If new information arrived during sentencing that mattered, I could continue the hearing and reconvene after the record was complete. In kitchen table language, I was not trapped by the first version of the story. If truth showed up late, I could still make room for it. That matters more than most people know. From the bench, I watch entrances closely. Marisol kept looking back toward the gallery, not to see who had come to judge her, but to make sure her son was still there. Linda Whitaker kept her ledger on her lap, both hands resting flat on it. Daniel Vega, Marisol's 13-year-old son, sat in the second row with a gray school polo under a black jacket, folding the cuff of his left sleeve inward and smoothing it flat again and again. Most people in the room were watching the lawyers. I was watching the people who had to live with whatever I did. Then the defense asked for something I did not expect. Counsel asked to let Daniel speak briefly as a character witness for sentencing purposes. The prosecutor objected, then withdrew the objection after a short exchange. I allowed it. A child should not decide a sentence. But when the law allows a relevant voice to be heard, I do not close that door just because the voice is young. Daniel walked to the witness box too fast, then slowed when he realized every head in the room had turned toward him. He looked at his mother first, then at me. His lawyer asked what kind of mother she was at home. He tried to answer seriously. Halfway through, he gave a nervous little smile and said, "My mom makes envelopes for everything: rent, bus money, my field trips, even leftovers. One time she had an envelope in the freezer that said, 'Ms. Whitaker, money do not touch even if you are desperate.'" I thought that was kind of funny. That was turn one. There was one brief sound in the room. Not laughter exactly. More like surprise, leaving several people at once. Daniel had not meant to expose anything except the truth as he knew it. But in one sentence, he turned the case from a theft file into a family trying badly and imperfectly to face what had happened. I looked at Marisol then. She shut her eyes for 1 second and then opened them again. She did not deny it. She did not shake her head. She simply sat there and let it be true. We took a 10-minute recess. When we came back, defense counsel told me there were photographs and a follow-up report not yet in the record. Officers had photographed 3 cash envelopes in Marisol's apartment freezer during a consent search after her police interview. One of them was labeled exactly the way Daniel had described it. I continued the hearing for 8 days so the record could be completed properly. That was my discretion at work. It meant I was willing to wait for the whole truth. Subscribe if you believe that courts are not only places where people are punished. They are also, sometimes, not always, but sometimes, places where people are met with something more than they expected. Subscribe for those moments. This is one of them. When we reconvened on January 30th, 2026, at 1:30 p.m., the defense introduced the photographs, the property inventory, and a blue spiral notebook taken from Marisol's kitchen drawer. That notebook was turned too. It was a cheap college-ruled notebook with a bent front corner and a grocery list on the back cover. On pages 3 through 9, Marisol had written every amount she took from Whitaker Floral and Gifts by date. Next to each amount she had written either a payment made, a note that said, "Not yet," or a date by which she hoped to pay it back. The numbers matched the business records exactly. The total written at the bottom was $2,840. That notebook did not soften the theft. It confirmed it, but it confirmed something else too. While she was still doing wrong, she was also keeping a record of the wrong as a debt, not a win, not something owed to her, a debt. Concrete evidence matters because feelings can mislead. Facts can point. These facts pointed toward a person already measuring the damage she had done. The defense also called Marisol's night shift supervisor from Ashford Medical Plaza. He testified that after the police interview, she asked for every extra cleaning shift available, including weekends, and said she was trying to pay back what I took. He was not polished. I trusted him more for that. Truth often arrives in plain clothes. Then Linda Whitaker gave the statement that told me what she actually needed. She said, "I do not need her sitting in jail thinking about me. I need my money back. I need her doing work that means something. And I need her son to see her tell the truth all the way through, not halfway." I wrote that down. Victims do not owe mercy. When one speaks with that kind of care, I listen closely. The defense by then was asking for something I was already considering. Marisol's lawyer said she stole, altered records, and abused the trust of a small business owner who had every right to expect honesty. I appreciated that he did not waste time pretending otherwise. Then he said something I did not expect. He said, "Your Honor, she does not need a lighter sentence. She needs a sentence she cannot hide inside." That was honest. The defense did get one thing wrong. Counsel spoke a little too much as if this had been a private family emergency that happened to touch a business. It was not that. It was a theft from a real woman whose shop absorbed the loss in time, money, and trust. I did not let the case become softer than it was. Compassion has to sit beside honesty, or it becomes useless. When Marisol spoke, she was not polished. That did not trouble me. She said, "I knew exactly whose money it was every time I touched it." Later, she said, "Ms. Whitaker trusted me with the lockup because I was steady, and I used that trust like it was mine." That was accountability without performance. It sounded costly to say. That is often how truth sounds. Then she said the sentence that settled the case for me. She said, "My son still thinks I fix things. I would like to be somebody he is right about." That was the moment I knew what I was going to do. I wrote it down. Not because I needed to remember it, because I wanted to. Long before I sat on a bench when I was 10, I came into our kitchen after midnight for a glass of water and found my mother at the table with 7 paper envelopes spread in front of her. Rent, light bill, groceries, church, school shoes. She had a short pencil in her hand. She moved $3 from one envelope to another and then moved it back. She did not know I was standing in the doorway. I had not thought about that scene in years. It came back to me then and sat down beside the case without asking. Subscribe before I continue. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. By the time the testimony ended, the room had changed. Daniel was no longer tugging at his sleeve. Linda Whitaker had closed her ledger. Marisol had stopped looking down. I had made my decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I have not told you the full sentence yet. I am about to. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. I sentenced Marisol Vega to 30 days in the county jail, all 30 suspended. I did that because I wanted the weight of jail in the sentence without wasting the one thing that could actually repair part of the harm, her labor, under supervision in public over time. I said, "I am ordering you to pay restitution in the full amount of $2,840 to Linda Whitaker, with the first payment due in 10 days and monthly payments after that until the balance is paid." I explained that the money did not vanish into the air. It landed on one person, one business, one set of nights spent rechecking numbers. Restitution was the first straight line she had to draw. I said, "I am also ordering 180 hours of community service at the Ashford Community Pantry, and those hours will be completed in inventory intake, donation sorting, and delivery logs. I chose that on purpose. She had used access and records to do harm. I wanted her doing careful work where other people would depend on her accuracy. Then I said, "You will complete a 16-week financial counseling program through Tri-County Family Services. You will provide probation with a written monthly budget for 12 months, and you will maintain at least 30 hours a week of employment or complete the bookkeeping certificate at Ivy Tech Community College by December 15, 2026. Fear had been making too many decisions in her life. I wanted skill, structure, and oversight to start making them instead. And there was one more thing. I said, "You will complete 10 family counseling sessions with Daniel Vega if his therapist and guardian agree that participation remains healthy for him." That was the relational part. Secrets had already done damage in that home. Courts cannot repair a family by command, but we can require people to sit still long enough for honest work to begin. I placed her on supervised probation for 18 months. I also told her that if she paid restitution in full within 9 months, completed at least 140 hours of service, finished counseling, and either held steady work for 6 straight months or completed the certificate program, I would consider early termination of probation. That was my benchmark. I did not say belief out loud in that moment by accident. I built it into the order. That was turn 3. The sentence was not a wall, it was a door with weight on it. Then I spoke to her directly. I said, "What you did cost Linda Whitaker money, time, sleep, and trust in the person closing her store at the end of the day. It also cost your son something less visible and just as real. It cost him a clean answer to what adults do when they are afraid." I looked at Linda Whitaker and said, "The law cannot give back the nights you spent checking drawers and wondering what you missed." Then I returned to Marisol and said, "The charge does not contain the whole of you. I believe you are capable of doing every part of this order." I said that plainly because I meant it, and I ended this way. I said, "Marisol, do not let your son learn honesty from your punishment. Make him learn it from what you do next." Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. The first reaction I noticed was Daniel's. He let out one long breath and reached into his backpack for a folded sheet of notebook paper. When counsel stepped aside, he handed it to his mother with both hands. I never read it. I just watched her take it the same way. As the room began to empty, Linda Whitaker walked to the end of counsel table and stopped a few feet from Marisol. She said, "Bring the payments to the shop on Thursdays if you want a receipt the same day." Marisol said, "Yes, ma'am." That was all. Before I stood up, I capped my pen and lined it up with the edge of my legal pad. On that day, that small act felt different. What happened after is simple and exact. On June 4, 2026, Helen Brooks, the pantry director, wrote to say Marisol had completed 126 service hours, rebuilt the pantry donation log, and had started arriving at 7:10 a.m. for an 8 a.m. shift. She added, "She still arrives 20 minutes early, and the boy who made everyone laugh in your courtroom now carries the folding tables beside her." Then on October 9, 2026, after restitution had been paid in full, Linda Whitaker sent a note through the clerk's office. It said, "She did what you said she would do." That was the second sentence from this case I kept with me. No appeal was filed. That meant something to me. It meant the energy of the case moved into compliance instead of argument. Sometimes that is the cleanest ending the law can offer. What I came to believe through this case is simple. Mercy only means something when it asks enough of the person receiving it. It would have been easier to impose a neat punishment and close the file. Fixed jail time, a fine, a warning, done. But careful mercy required more from me and far more from her. It required attention, patience, and a sentence designed for a person rather than only for a charge. This case gave something back to me too. It gave me back trust in the usefulness of careful judgment. If you have been in the defendant's position, if you have caused real harm and do not know whether there is a path forward, I can tell you one thing I look for from the bench. I look for whether you have stopped arguing with the facts, not whether you can speak beautifully, whether you can name what you did, who paid for it, and what you are prepared to do next. If you can do that honestly, then do not waste that moment. Build from it. And if you have been in the victim's position and mercy was asked of you when you were not sure mercy belonged in the room at all, I would never tell you what to want. I can only tell you what I have seen. When victims chose careful mercy, not denial, and not surrender, it sometimes gave them back a piece of authorship over what happened. Not every time, not quickly, but I have seen it. Subscribe. I'm about to tell you what happened after the sentence, whether this person did what I believe they would do. Subscribe so you are here for that part. It is the part I care about most. The part I care about most is not that I gave a lighter sentence than some people would have preferred. It is that the sentence held, the payments were made, the hours were served, the counseling was attended, the work was done. And on one specific morning in June, a woman who once altered numbers at closing time was standing in a pantry 20 minutes early to make sure other families could receive food in the right amounts and on the right shelves. I opened with that image for a reason. A woman arriving early, a boy carrying folding tables beside her, a small room somewhere far from my courtroom being set in order by the same hands that once helped disorder enter another room. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you speak in the comments, speak like people who understand that justice and humanity are not opposites and that both deserve careful language.